Hello and welcome back to our Employment Bite-Sized Seminar series brought to you by the Employment Law Group. My name's Sarah Ibrahim and I'm here with my colleague Emily Moore. Hello, Emily.
Hi, Sarah.
So today, Emily, we're going to be discussing collective redundancies. And a lot of that is because we've now heard again from Rishi Sunak, who's the Chancellor, and he's been talking about what are viable and unviable jobs. So we're anticipating there probably is going to need to be various collective redundancy exercises. Now, it's quite interesting. We've had recently the BBC who did a Freedom of Information request, and they were asking about the number of people who are notified at risk of redundancy, because when you have these larger redundancies, you do have to notify the Insolvency Service. And they found in a 3-month period, and that's between May and July this year, that 380,000 jobs were notified as being at risk. Now, that's considerably more than the number of people who were put at risk during the credit crunch in 2009. But I know, Emily, you've got some more statistics for us that may be of interest.
Yes, Sarah. So notably, the ONS has now released statistics for September. And these show a marked decrease in employment, particularly in the 16 to 24 age group. Now, of course, this could reflect the types of industry that people of this age group are frequently employed in. So hospitality and retail have obviously been hit very hard. So that probably explains the marked increase, particularly in that age group. And in terms of redundancies, we're seeing the largest annual and quarterly increases since 2009, as you alluded to there. And something to be aware of in terms of redundancy, in terms of a recent development, is there's been a joint statement between ACAS, the TUC, so the Trades Union Congress, and the CBI, so the Confederation of British Industry. And they've issued, as I said, a joint statement just on the 24th of September. And in that joint statement, they allude to 5 criteria for redundancies. So very briefly, those 5 criteria are: number 1, openness. So people need to understand the situation. Number 2, being thorough, which includes training for staff representatives. Number 3, genuine consultation, so hearing people's views and being open to alternatives. Number 4, fairness, so notably no forms of discrimination. And number 5, dignity, so even if the news of redundancy is being delivered remotely, ensuring that dignity is preserved. So ACAS, I think, are reporting issues that companies have either never conducted a redundancy exercise before, or they're blatantly ignoring the rules. So, for example, firing people with 1 day's notice by text or WhatsApp. So with that in mind, today we're focusing on consultation and notification. And I think, Sarah, you're going to talk firstly a bit about notification obligations.
Absolutely. I think we have to start at notification, and that obligation is triggered when the employer is proposing to make at least 20 employees redundant within a 90-day period. So that's very important, but it has to be considered in the context of what is an establishment, because it's 20 people from an establishment. So under the Trade Union and Labour Relations Act, which I'll refer to as TULVA from now on for brevity, under Section 188 of that Act, this has to be in line with the European Directive, which is 98 out of 59, essentially the directive on collective redundancies. But if we could just touch upon some case law, I think you can take us through, Emily.
Yes, Sarah. So on that point, there's some case law from the European Court of Justice on that point. And it talks about a local employment unit that any workers are assigned to carry out their duties. So that doesn't mean that a unit has to be legally or administratively distinct. And that could be highly relevant in the UK, as we know that a lot of restaurants and shops have been badly affected, and these entities are likely to be organised as chains. So it's very important to, having regard to the case law, to be aware of when the threshold notification the threshold for notification may be met. Any other points, Sarah, on the threshold point?
Yes, I want to go through this notification, particularly the notification that you have to fill out and send to the Secretary of State. That's called an HR1 form. Now, the government guidance makes it clear this form must be filled out for every establishment where 20 or more redundancies may occur. So that form requires you to confirm that you are in fact undertaking the redundancy exercise in what we would call a legally compliant way. So Emily, that means including what kind of consultation that you're undertaking, is there reasonable notice that's been given, and it gives you the opportunity, that form, to provide an explanation if there's been any default. So this HR1 notification has to be given at least 30 days if you've got 20 or more people at risk of redundancy, but it increases to 45 days if 100 or more people are at risk. So you do need to be on top of that notification guidance. Now, the failure to notify the Department for Business, Energy and Industrial Strategy, as it's now called, may lead to a fine. Now, most people remember this fine used to be £5,000, but it's now uncapped. So you can have that liability, which could be quite significant. Now, this is independent of any claims that may be brought by trade unions or employees who is dismissed as redundant. So if you don't comply, it can be quite a costly exercise. So perhaps we can move on, Emily, to who you were giving notification to.
Yeah, sure, Sarah. So there's quite a lot to cover here, but I'll try to be as concise as I can. So under TOLRA, appropriate representatives of affected employees are people that have to be notified. So if you have a recognised trade union, then it's going to be representatives of that union or employee representatives. And elections for elected representatives are governed by Section 188A of TOLRA. There's various requirements about those elections. They have to be fair, meaning that any candidates are from the pool of affected employers and no person is unreasonably excluded from election or voting. And then you have employers who do not have a recognised trade union, so additional time and consideration will need to be applied to the election of employee representatives. Or if there are already representatives who've been appointed for other reasons, then there needs to be very careful consideration about whether those individuals can be consulted about dismissals and receive relevant information. So moving on to consultation, the joint statement from ACAS, the TUC and CBI emphasise that there has to be a genuine consultation. So employers can by no means simply present a redundancy plan as a fait accompli. So there are going to be specific challenges in light of the pandemic in terms of how communication is going to be affected with employee representatives. So employers need to be thinking about whether they can allocate their IT resources to ensure that employee reps can communicate effectively with each other and with the employer during the consultation period. Making sure that employees feel like they are being properly consulted with all the barriers that there are at the moment, what with remote working. And during remote working, it's obviously very tempting to simply rely on written communication. But as an employer, you need to be thinking, am I ensuring that there are sufficient video calls, telephone calls or the like, to make sure employees feel like they are being genuinely consulted with. And Sarah, are there any other crucial points to be aware of in terms of consultation before we wrap up?
Absolutely. I want to say in summary, there are many component parts to a collective redundancy exercise. Employers are going to be feeling very pressurised because of the economic situation created by this pandemic, but they must set out a robust plan for any redundancy exercise in advance, because otherwise it could be very costly. So that's everything from failures to notify to failures not just under TOLRA but under the Employment Rights Act. So do make sure that you really do have that plan in place before you start. Thank you very much, Emily.
Thanks, Sarah.